5 seconds to go. Start. However, the view expressed in SBI versus Rajkumar is that there is no vested right to have the matter considered under the former scheme, and the governing scheme would be one which was in force when the applications came up for consideration. Rajkumar Supra and Chakravarti Singh Supra did not have the occasion to notice Abhishek Kumar Supra. However, Canara Bank Supra did notice Rajkumar Supra and Chakravarti Singh Supra but struck discordant notes therewith. The decision in Jaspal Kaur Supra was relied on by the coordinate bench in Canara Bank Supra to hold that the cause of action to be considered for compassionate appointment arose when Circular Number 154 of 1993 dated 8th May 1993 was in force. Thus, as per the judgment referred in Jaspal Kaur case, the claim cannot be decided as per 2005 scheme providing for ex gratia payment. The circular dated 14th February 2005, being an administrative or executive order, cannot have retrospective effect so as to take away the right accrued to the respondent as per circular of 1993. Noticing the divergent views as above, another coordinate bench referred the matter to a larger bench in State Bank of India versus Shiv Shankar Tiwari. Close on the heels of the reference made in Shiv Shankar Tiwari Supra, a three-judge bench of this court held in N.C. Santosh versus State of Karnataka that for consideration of a claim for compassionate appointment, the norms prevailing on the date the application is considered should be the basis for consideration. Paragraph 19 of the decision is the relevant paragraph where the dictum is to be found. NC Santosh Supra does seem to have impliedly overruled Canara Bank Supra by holding that the norms prevailing on the date of consideration of the application should be the basis for consideration and not the norms as applicable on the date of death. One would have thought that the issue attained finality with the decision in NC Santosh Supra being the decision of a larger bench of this court. However, the controversy seems to have re emerged with subsequent decisions of this court being rendered which are in line with Abhishek Kumar Supra and Canara Bank Supra and contrary to Rajkumar Supra, Chakravarti Singh Supra and N.C. Santosh Supra. Within 6 months of the ruling in N.C. Santosh Supra came the decision of another bench of 3 judges in state of Madhya Pradesh versus Amit Shrivas where it was held that it is right to say that there cannot be any inherent right to compassionate appointment, but rather it is a right based on certain criteria, especially to provide succor to a needy family. This has to be in terms of the applicable policy as existing on the date of demise, unless a subsequent policy is made applicable retrospectively. We place on record that the decision in Amit Shrivas Supra refers to an earlier decision in State of Gujarat versus Arvind T. Tiwari in paragraph 16 extracted above, as if such decision lays down the law that a subsequent policy could be made applicable retrospectively. While we have been unable to trace any such law in Arvind T. Tiwari Supra, this is what we find in paragraph 18 of the said decision. Thus, the question framed by this court with respect to whether the application for compassionate employment is to be considered as per existing rules or under the rules as existing on the date of death of the employee is not required to be considered. It is indeed debatable whether a policy for compassionate appointment, which is in the nature of an executive order, can have retrospective application. Be that as it may, soon after the decision in Amit Shrivas Supra, there have been two decisions of coordinate benches of two judges in Indian Bank versus Promila and State of Madhya Pradesh versus Ashish Avasthi. The latter, upon considering the decisions in Amit Shrivas Supra and Promila Supra, expressed the view in paragraph 5 thus: as per the settled proposition of law laid down by this court for appointment on compassionate ground, the policy prevalent at the time of death of the deceased employee only is required to be considered and not the subsequent policy. The decisions in N.C. Santosh Supra and Amit Shrivas Supra, rendered by three judge benches, are clearly at variance on the point as to which of the policies would be applicable to decide an application for compassionate appointment, the policy prevailing as on the date of death of the deceased employee or the one prevailing on the date of consideration of the application for compassionate appointment. The reference made by Shio Shankar Tewari Supra is yet to be decided by the larger bench. Hence, we have considered it appropriate to refer to the decisions rendered subsequently so that an informed and authoritative decision is made available on this tricky issue, or if at all the necessity arises to make an appropriate reference to a still larger bench having regard to the conflicting views expressed by coordinate benches of three judges and a host of divergent views of benches of two judges. Since Canara Bank Supra has been referred to a larger bench and the larger bench is yet to give its decision, learned counsel for the appellant was heard to submit that we ought to await such decision. However, we can brook no further delay, having regard to the lapse of time, since the judgment was reserved on this appeal, because the decision of the larger bench is not in sight, and most importantly, the respondent is waiting for more than 2 decades, not knowing what destiny has in store for him. We have noticed the core issue arising for decision as well as the guiding legal principles for appointment on compassionate ground herein above. As observed earlier, decision on the core issue would also require us to answer certain sub issues. We propose to answer them too in the process. The first sub issue is in relation to the lapse of time since the respondent's father passed away. It has been in excess of 2 decades. It does not require anyone to put on a magnifying glass here to assess the time that has been taken for the application of the respondent for compassionate appointment to be finally decided. The parties have reached the third tier in the second round. One of the foremost factors for appointment on compassionate ground is that the same should be offered at the earliest. Unless appointment is made soon after, the need to mitigate hardship arises, tiding over the immediate financial crisis owing to sudden premature and untimely death of the deceased employee or medical incapacitation resulting in the employee's unfitness to continue in service, for which benevolence is shown by offering an appointment may not exist, and thereby the very object of such appointment could stand frustrated. More often than not, spurned claims for compassionate appointment reach the high courts or even this court after consuming substantial time. The ordinary rule of litigation is that right to relief should be decided by reference to the date on which the suitor entered the portals of the court. Stop.